Have you ever thought about bankruptcy? Welcome to Your Clear Thinking. I'm Roderick Mitchell, author of Credit Straight Talk, Clarity on the Conspiracy. This video is part of a series of videos designed to help you build a solid credit foundation. In this video, I'm going to talk to you about bankruptcy. Bankruptcy in all forms is a very serious matter that should not be entered until every option is explored and fully understood. What I mean by fully understood is a complete explanation of the impact on your future if you do or do not complete your bankruptcy obligation. The forms of bankruptcy are Chapter 13, Chapter 7, and a combination of the two often referred to as Chapter 10. Bankruptcy should be your last option when nothing else can help you in your financial situation, because there will be repercussions whether or not you complete the bankruptcy obligation. The difference is how severe will they be. The long-lasting negative impact on your credit rating is going to be there for 7 to 10 years, depending on the type of bankruptcy that you enter. It can affect your future credit, employment, housing, and even your children's education. You will be required to complete a credit counseling course that you must pay for and receive a certificate of completion as a part of qualification for bankruptcy. Failure to complete the credit counseling course will disqualify you from entering any form of bankruptcy. Let's start with Chapter 13, also called Debtor's Court. Chapter 13 is a plan to reorganize your past due debt. It is a form of protection from creditors pursuing you for repossession and foreclosure actions. You will have to create a plan to repay your past due debt and submit it to the bankruptcy court. When an adequate plan is submitted and approved in bankruptcy court, your recovery will begin. You will have to continue your original payments of the original obligation and pay your monthly agreed bankruptcy payment. When you complete your bankruptcy agreement obligation, you will be discharged from bankruptcy with a letter of completion for you to present to your creditors. Failure to pay the Chapter 13 payments or the original remaining financial obligation payments will violate the Chapter 13 agreement and result in a dismissal from bankruptcy. The dismissal will allow you to be pursued legally by your creditors again. Next is Chapter 7 bankruptcy. It allows for liquidation or repossession of the collateral connected to your financial agreements that were not paid in full. The income from the sale of the liquidated or repossessed item will be used to pay your balance that you owe the creditor. If the income received from the sale of the collateral or repossession and the sale does not cover the entire balance, the creditor will have to accept that loss because you are free from all payment obligations once it has been ratified in bankruptcy court. Your only remaining penalty is you'll be penalized on your credit report for a period of at least 7 years, possibly 10 years. Now let's talk about the hybrid form of bankruptcy, referred to as Chapter 10. It is a combination of Chapter 7 and Chapter 13. You will reorganize the chosen debt into a payment plan and continue with your original payment agreement and make a bankruptcy payment like you do in Chapter 13. The delinquent balances of the unchosen agreements will be treated like Chapter 7 and discharged. The common use of this form of bankruptcy is to protect a home and a vehicle to allow you to continue normal life, but get rid of the non-essential consumer debt agreements. The pros and cons of each form of bankruptcy depend on your personal situation. Chapter 7 is the most devastating as far as you having surrendered everything and you start with a negative credit rating and literally no credit. Your statute of limitations will begin immediately for your Chapter 7 bankruptcy once it's ratified in the court proceeding. And its negative impact will end sooner because of your immediate restart. A default on Chapter 13 agreements will result in a dismissal from the plan, allowing for the restarting of collection actions, and will start new statute of limitations. My personal opinion of a conspiracy type situation begins with the requirement for credit counseling. It demonstrates that an entire secondary industry is funded by consumers having credit problems. Bankruptcy attorneys are making record profits because of credit consumers needing legal representation. Credit counseling instructors are being automatically included in all bankruptcy in all forms. The perfect fit of this situation is too good to think it is a coincidence and it just happens this way. The knowledge of consumer credit is effectively hidden from you until you have made mistakes that are profitable for the credit industry. If the subject of consumer credit was a required course of study in public schools, there is a chance that record numbers of credit consumers needing any kind of bankruptcy would drop drastically. The need for bankruptcy attorneys and credit counseling could be cut in half because you would grow up and mature understanding the vital role that your credit plays in your present life and in the future of yourself and your family. In this video, I talk to you about bankruptcy and some of the things you should consider before you make that decision. Remember to subscribe below and select the playlist and see all the videos in this series. I'm Roderick Mitchell, author of Credit Straight Talk, Clarity on the Conspiracy. Visit my blog, yourclearthinking.com, and remember, together we rise.